So today we are discussing the Decree Federal Law number 26 of 2020. This is a federal law that was issued like a month now from now. What is the date here? In 27th of September it was issued. However, it was not published until maybe sometime in December, 6th of December or something. And it created a big discussion in the media, because one of the basic things it was publicized in the news that it removed the requirement for 51% shareholding of local UAE partner. Some of you would know that in the UAE, all the companies, at least the LLCs and most activities, would have a silent partner of 51%. And there are a lot of arrangements in the market where people just get a sponsor and then they have nominee shareholder agreements and stuff like this. This is actually, from a technical point of view, is illegal. I remember during 2015, Saudi Arabia decided to activate the anti-coverup law, and this created big issues in Saudi and created a momentum in the UAE for different stakeholders asking whether there is an anti-coverup law in the UAE. And yes, there is, much less harsh than Saudi, but there is an anti-coverup law. Whether it's activated, no, it's not activated until now, and most of the companies are operating. So when this law was issued recently, it was publicized under the big slogan, now 51% shareholding is removed. We will see from going through this law that it's not actually removed, but it's moved from the federal law to other provisions. So going through the main amendments, you would see that in a lot of instances of this amendment, the legislator decided to remove the provisions from the law and delegate it to the authority or the minister or the cabinet, so that they can issue more quick amendments. This is a new trend within the UAE, that many parts of the law are removed from the federal law or from the local law and are delegated to the cabinet or to a minister, so that they change this a lot. And they're actually changing it year after another, or if every few months. Also, this law is now grabbing some companies that were not under it. So companies where the government is a shareholder or indirect shareholder is now being covered if they opt to be covered under the law. So whether it's incorporated by a law or incorporated directly as a private company, they can opt to operate under this law if they wish to do so. Then the most controversial article is article number 10, which originally required 51% shareholding to a local UAE national, or that the company is owned 100% by Gulf nationals, if possible. So after the amendment, it added two things. First, it removed the 51% from the law completely, and it allowed the authority to decide how much is the percentage that is necessary for this. And they told the authority that they should allow percentages in accordance with a cabinet decision that's not issued until now. So we are yet to see a cabinet decision to implement the provisions of this law. Then based on this cabinet decision, each economic department will decide separately what percentage for locals to apply for which activities. This exercise happened before. So in 2018, the UAE have issued a federal foreign direct investment law, which was under number 19 of 2018. Then they said there will be a cabinet decision to activate this law. And this cabinet decision was not issued until 2020, in March 2020, actually, when they issued decision number 16 of 2020. And then this decision included number of activities, and it included some capital for each of these activities to allow foreign direct investment. And within the decision, it did not allow direct foreign investment, but it said that each of the authorities, so each of the Dubai Economic Department, Abu Dhabi Economic Department, Sharjah Economic Department, wherever emirate, will issue its own regulations. In practice, it didn't happen. So by the time they were going to issue the regulations between March and September, this new law was issued, and there are no actual departments that issued the regulations. I am aware that 3 emirates at least, Abu Dhabi, Dubai, and Sharjah, have created portals that allowed people to subscribe and to invest directly in the market. But it was more of a case-by-case basis and on big projects rather than just small investors or medium investors coming to the market and trying their luck. So it was more of direct investment involved with the government. So now with this law, we are expecting another decision, another cabinet decision, and another DED decisions to decide which activity needs how much percentage. This might be problematic to a lot of companies if they actually decide that most of the activities can be done without a local partner, because the current situation in the market that each company has a 51% shareholder local partner who is a silent sponsor and who takes probably a fixed amount. Sometimes they take a percentage, but if they are taking a percentage, it's not a big deal because they will sort out something somehow. But for those who are taking 1 dirham, 100,000 dirham, whatever the fixed amount, if their requirement is no more a requirement, then it will actually cause issues, because if companies are trying to avoid them, even if they're not bad people or crooks or someone who wants to take over your company, you will be cutting their main source of income, which will create issues and will send a lot of cases to the court. So this is one of the most important changes. The other important thing that the previous law in most of its articles have excluded all the activities related to insurance and banking from its provisions. We would see that a lot of the activities in this law have removed this exclusion and replaced it with a requirement that it has to be in consideration with the regulations from the central bank or the insurance authority. And now the insurance authority itself is being put under the central bank, so it's basically the central bank and its organs. Also, we would see that Article 11, like the next article changed in the law, removed the prohibition to establish companies that do crowdfunding or accept investments from third parties. So previously, under the companies law, you were not allowed to establish a company that under the federal law. You could do this in the IFC or ADGM, but not under the federal law, where you can accept investments from different people and create a fund, for instance. So now they removed the prohibition to do this, but still no regulation on how to actually do it. Also, they removed the requirement that a one-person company is owned by a local only. So this is in line with the same percentages. So now, according to the law, whether it's it's a local or non-local, they can establish a one-person company. But until there is a regulation that says what are the percentages, this is not there. In relation to the one-person company also, they removed the requirement that the name of the owner is included in the name of the company. So previously, if I want to establish a one-person company, I would have whatever trade name, then for its owner, Ahmad AlKotby. Now, no, it's just trade name, one-person company, and I don't need to have my name included. Also, there was a new requirement that all articles of association of LLC companies would require a way to solve disputes among partners. Although it seems obvious, we have seen a number of contracts that does not have such provision, and usually people went to court, but then the new law or the new amendment included this clearly, that you have to include this in your article. So if you are ever operating a company that doesn't have this in their articles of association, then you would have 1 year to include this in your articles of association, or the law puts a very bad punishment, which is considering your company to be dissolved by law. Also, throughout the law, they are decreasing the percentage of shareholders that require amendments, calling for a general assembly meeting, calling for an urgent general assembly meeting, different percentages. So instead of a quarter of the shareholders, now it's 10%. In one instance, sometimes it was 75%. They decreased it to 50%. And they have also decreased the number of the time limits necessary. So instead of having 21 days, they had it 15 days for calling the General Assembly. And they added a lot of provisions related to the e-meetings, because many companies wanted to do e-meetings, especially at the time of COVID, but they were stopped because of no provision in the law, and it's not included in their articles of association. So now the law, although it requires that you add this to your articles of association, but even if you don't have it in your articles of association, you can actually still do online meetings unless someone is against it from the shareholders or something like this. Then in the UAE, unlike most of the countries, you would have the limited liability company as the main company, and then any other companies that don't have provisions, you refer to the limited liability company. But in the UAE, it is actually the other way around. So the main company is the public stock company. And that was creating a lot of issues, because the public joint stock companies have more detailed provisions, have more focus on its management, the relationship between the board of directors and the shareholders, which does not actually apply to the LLC. So Article 104 had a new provision that the cabinet would issue a decision where where it will exclude some of the provisions from the public joint stock companies and introduce some new provisions for the LLCs. Then on this point, the provisions for the LLC stops, and then the law starts dealing with the public joint stock companies. I'm not sure about the time. Do we have time to go through some of the changes to the joint stock company, or we can stop at the LLCs for the time being, Wissam?
2 more minutes.
Okay.
You decide.
Ahmed, I suggest you maybe to take to mention also the branch and the service agent. How is it being affected by the law? Because I mean, this is a typical situation where you have either an LLC or a branch with a service agent.
So this is actually jumping all the way through the public joint stock company. So now the law removed the requirement for a service agent. A service agent in the UAE is a local partner, whether a person or a company, that provide PRO services or logistics services for a branch or a sole establishment, a branch of a foreign company or a sole establishment in the UAE, so that they facilitate their labor contracts, they facilitate their immigration file. They are not actually a partner, they are just a sponsor, and usually you had their name on your trade license as a service agent, and they would assign to you a PRO or some officer who assist you with getting the visas, running around the Ministry of Human Resources, like Ministry of Labor previously. Now this requirement is removed. So if you are a foreign company, you want to start a branch within the UAE, you don't need a service agent anymore. There is no specification that DED, like the economic department, has to issue any provision, but until now this is not activated. So if you are a branch of foreign company, you are not yet allowed to remove the service agent, and it's not clear. But this does not create big problem like the local sponsor who owns 51%, because this is usually a contract that doesn't have partnership or part of the equity in it. So you just remove them and somehow you will move forward. There will be a requirement by a number of authorities and entities to start provisions, because now if you want to hire someone, you would usually require the involvement of a local partner, and then this local partner will have what's called an e-signature card and some cards that are exclusive right now for locals. So they would need to create a system or something where you can have these cards for non-locals as well. It's not a big issue, but sometimes it takes time to activate the provisions of the law, so that we do not go beyond the allowed time limit.
Yeah.
Um,
Ahmed, thank you very much. We will